Dear friends, the proposition I am going to put forth before you arises out of the Motor Vehicles Act. As we all know pretty well that only a third party can maintain a claim petition under any of the provisions of the Motor Vehicles Act, either amended or before. An owner of the motor vehicle is the first party to the policy of insurance. The insurance company is the second party, and anybody else is the third party. An owner of the vehicle or his LRs cannot maintain a claim petition against his own insurance company for the reason that an owner of the vehicle is not a third party. The Supreme Court of India has held the legal position clearly in Sunita Rathi's case, Jerome's case, Rajni Devi's case, and Zuma Saha's case. The term owner is defined under section 2, subsection 30 of the Motor Vehicles Act. In the year 2009, the Supreme Court of India has created a legal fiction in Ningamma's case, reported in 2009, volume 13, Supreme Court Cases, page 710. According to the legal fiction, a person who had borrowed the motor vehicle from the registered owner involves in an accident cannot maintain a claim petition against the registered owner and the insurance company of the vehicle so borrowed, because the law deems such a borrower to be the owner by himself. In other words, the borrower of the motor vehicle would step into the shoes of the owner, would become the owner by himself, and would cease to be a third party. And thus, the claim petition by the borrower or his LRs is not maintainable under section 147 of the Motor Vehicles Act. The liability of the insurance company towards third party is the statutory liability. The said position, which has been laid down by Supreme Court in Ningamma's case in 2009, volume 13 SCC, page 710, was reiterated by the Supreme Court in Ram Kiladi's case, reported in 2020, volume 2, Supreme Court Cases, page 550. Now let us shift our focus to the contractual liability of the insurance company. Here I mean the benefit of the personal accident coverage. From 1/8/2002, the IRDA has introduced the benefit of personal accident coverage. The enabling provisions are General Regulations number 36 of the India Motor Tariff and section 3 of the Policy of Insurance. According to the said regulations, a registered owner cum driver of the motor vehicle is entitled for compensation of Rs 1 lakh in case of two-wheelers and 2 lakhs in case of four-wheelers, both for permanent disablement and for fatal injuries, provided he happened to be the registered owner cum driver and must have held a valid driving license. Of course, an additional driver or co-driver is also covered. In the year 2017, in Rekha's case reported in 2017, volume 2, TNMAC, page 674, Division Bench, the Division Bench of Madras High Court has directed the IRDA to consider the maximum amount of compensation enhanced to Rs 15 lakhs from Rs 1 lakh and 2 lakhs respectively. The IRDA had agreed for the proposal, and a circular came to be issued on 20th September 2018. So, from December 2018 or 2019 onwards, the maximum amount of compensation payable under the PA coverage stands enhanced to Rs 15 lakhs. It is a compulsory coverage and the premium is the basic premium. Now, the question remains to be answered is this: by a legal fiction created by the Supreme Court of India in Ningamma's case. For the purpose of the statutory liability, the borrower of the motor vehicle is deemed to be the registered owner. Whether the same legal fiction can be extended to the same borrower for the purpose of claiming the benefit of personal accident coverage. Because it is the same class of persons, namely the borrowers. For the purpose of statutory liability, he is deemed to be the registered owner. Can he be deemed to be a registered owner for the purpose of the contractual liability, so as to claim the benefit of the personal accident coverage? If you want to say the answer in the affirmative, I may say that it is not so easy, because the liability of the insurance company qua the PA coverage is purely contractual. The terms of the contract or the terms of the policy of insurance cannot be rewritten. It has been held by the courts across the countries in umpteen number of cases. The Supreme Court has read down the definition of the term owner by a legal fiction in Ningamma's case for the purpose of adjudication of the statutory liability. Whether it can be done in case of contractual liability is the million-dollar question. So my proposition before this August forum is this: whether a borrower of a motor vehicle from the registered owner can be deemed to be the registered owner for the purpose of claiming the benefit of personal accident coverage under GR 36 and Section 3 of the Policy of Insurance. In other words, whether the legal fiction created by Supreme Court in Ningamma's case for statutory liability be extended to the contractual liability under Section 3 of the Policy of Insurance by deeming the borrower to be a registered owner for the purpose of the benefit under the PA coverage. The process involves the doctrine of reading down the provision of general regulations and the terms and conditions of the policy of insurance, and in fact even rewriting the terms of the contract, which is not so easily permissible as per judgments of the courts across the country. I may request the members of this forum to think it over, search and research the law, and find out a solution so that the same class of persons, being the borrower of the motor vehicle and the registered owner, who stand defeated for the purpose of statutory liability, may stand gained for the purpose of the contractual liability, of course subject to the four corners of law. Thank you.